Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and let's get right to the docket. First, Tessa Majors case update. Second, a horrific crime in Brisbane, Australia. Third, the Harvey Weinstein charges explained. Fourth, forcing someone to watch the documentary Roots can be a criminal act. And finally, our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch from Crime Talk, and thank you for tuning in. First, I don't know if you've noticed, but we are rapidly approaching 75,000 subscribers. And when we get there, we're going to do something special. Haven't decided exactly what it's going to be, but it's going to be big. So if you haven't hit that subscribe button, please do so now. Let's hit that like button as well. Hit that notification bell so you get notified of when we put up new content or when we go live. And finally, leave a comment in the section below. We want to know what you think about what we are talking about today. So let's get to the docket. First, a Tessa Majors case update. For those of you who do not recall, Tessa Majors was a college student, 18 years old, and on December 11th, she was walking in a park near Columbia University where three young men basically tried to rob her, and she struggled, she fought them off, and they stabbed her. Tessa Majors tried to get help. She was able to get back near the college campus where a security officer found her and immediately rushed her to the hospital. Now, what's really sad about this situation, not only is Tessa Majors deceased because of this, but that the young age of the individuals involved. First, a 13-year-old suspect was arrested in connection with the stabbing. He, of course, said, "It wasn't me, it was these other individuals." Well, the 13-year-old is actually still being tried as a juvenile for felony murder and a litany of other counts. The other teenagers that have been charged, first is Luciano Lewis, 14, is being charged as an adult with second-degree murder, first-degree robbery, and second-degree robbery in the fatal stabbing of Miss Majors. Another 14-year-old, Rashawn Weaver, was charged Saturday as an adult as well in the killing. Tessa Majors is the daughter of James Madison University professor and novelist Inman Majors, who lived in Waynesboro for several years before moving to Charlottesville. Obviously, this is a tragedy all around, not only for the Majors family, but when you have young people like this going out and committing crime that do not really appreciate the seriousness of what they're doing, suddenly get a real-life reality jolt when they're looking at spending the better part of their life in prison. I can tell you, reality hits real quick when you start telling a 16, 17, 18-year-old kid, 19-year-old kid that they're looking at spending the rest of their life or maybe 60 years in prison. They simply cannot fathom that concept of time because they have been around for such little time, and really they give up hope rather quickly. And let's face it, no 16, 17-year-old kid wants to go to adult prison. That is not going to be a good time for anyone. Next on the docket, a horrific criminal case in Brisbane, Australia. And this is a crazy case and makes no sense whatsoever. Somewhat shocking and surprising that it came from Australia. Now, obviously, this is the kind of stuff you expect in America, but you just don't hear about it that much in Australia, so it kind of makes it even more shocking. But the facts involve a former rugby player, Rowan Baxter, who is 42, and he is alleged of killing his 3 children after dousing them with gasoline and his wife, and then watching the car burn while he stabs himself. When his wife gets out of the car, isn't on fire, he attacks individuals trying to help his wife. So let's get into the details. And for those of you that have the children listening at home, you may want to cover their ears. So the facts play out on Wednesday, February 19th in the early morning. National Rugby League star Rowan Charles Baxter, 42, is spotted filling a jerry can with fuel at a local service station. At about 8:20 a.m., Baxter dives into his estranged wife's, Hannah Baker's, white Kia Sportage as she was preparing to do the school drop-off on Raven Street, which is a wealthy suburb in Brisbane, apparently. He then douses Miss Baxter, who is 31, and their 3 children, Aliyah, 6, Lanaya, 4, and Trey, 3. He then sets the car on fire. Neighbors hear an explosion, which sounds like a gas bottle blast. It's reported that there were at least 4 explosions. Baxter then grabs a knife from the SUV and then stabs himself in the chest. He apparently tries to stop neighbors from saving his wife and children before dying in the street. Miss Baxter escapes the burning car and screams, "He poured petroleum on me." Horrified witnesses could actually see her skin peeling off her body. One heroic neighbor hosed her down in an attempt to save her life and suffered burns himself. She was ultimately rushed to the hospital in critical condition. Ultimately, Wednesday evening, Miss Baxter dies of the injuries suffered at the hands of her husband. Now, many of the family and friends believe that Rowan Baxter was a loving family man and are obviously shocked by what took place. I think anybody would be. It's still unclear exactly as to why he would do such a thing, particularly to, obviously, his ex-wife and his children. Literally to watch them burn before his very eyes. That is horrendous. That is evil. Next on the docket, the Harvey Weinstein charges further explained. The Harvey Weinstein trial is in about 19 days if you include the last 3 days of jury deliberations. The jurors have asked several questions over the course of the last several days, and a lot of it has to do with clarifying questions regarding the charges in the indictment. Now, I am not going to profess to be a lawyer licensed in New York and necessarily nuanced in the rules in New York and nuances of those particular charges. However, having looked at the charges, the indictment, and reading some law on the matter, it appears that I think I can provide a simple explanation for you all, and hopefully it'll clarify for everybody. Because I'll be honest with you, their system is a heck of a lot different than it is here in Colorado. As far as charging, it makes not a whole lot of sense to me, so that's why I had to do some studying. When in doubt, break out the rules. So, just so we're clear, Weinstein faces 5 charges. First-degree criminal sexual act, first-degree rape, third-degree rape, and 2 counts of predatory sexual assault. The 2 first-degree charges are each punishable by at least 5 years and a maximum of 25 years in prison. The third-degree rape charge is punishable by probation and up to 4 years in prison. And the predatory sexual assault charges come with a sentence of 10 years up to life in prison. But several of the charges are either or counts, and what that means is they're charged in the alternative. Weinstein can only be convicted of, at most, 2 charges. One based upon Miss Mann's allegations, one based upon Miss Haley's allegations. As a quick refresher, Miss Haley testified in court that Mr. Weinstein pinned her down and forced sex on her at a Manhattan apartment in 2006. For that, Weinstein is charged with first-degree criminal sexual act. Now, Miss Mann testified in court that Weinstein raped her at a New York hotel in 2013, which she described as an abusive relationship. Mr. Weinstein is charged with first-degree rape and third-degree rape, though he can only be convicted of one of those charges. What the district attorney is saying is that there are 2 charges. One is more serious, one is not as serious. but the same evidence could support either one. It's kind of like a lesser included offense. The lower offense necessarily is included in the greater offense, and so they can decide, but they can't be both. Now, if the jury finds beyond a reasonable doubt that Mr. Weinstein committed either of the first-degree sexual act charges, then they must make a separate finding on Skiora's testimony. Now, Skiora testified that Weinstein barged into her apartment and sexually assaulted her in the winter of 1993 through 1994. If the jurors believe that incident constitutes a first-degree rape or a first-degree sexual act, then the first-degree charges, if the jury finds the innocent involving man, is a third-degree charge, though that cannot be escalated into a predatory sexual assault because the predatory charge requires 2 first-degree sex crimes. Now, there were at least 3 other women who testified what we've talked about before as 404B or prior bad acts witness evidence to come in, and those are not charges that Mr. Weinstein faces. Those evidence are there to basically show that he acted in a pattern. It was his modus operandi that he did various things in a particular way, and he acted consistently. Not to show that he's a bad guy, even though they really do, but to show that he acted in conformity with a certain operation of bringing somebody to his room and pressuring them into having sex or whether it's consensual. Ultimately, the prosecution has to show that Mr. Weinstein had sexual relations with these women and they did not consent. It was not a consensual encounter. There's big words like forcible compulsion, intent, and consent. What that really comes down to is consent, and lack of consent results from forcible compulsion or circumstances under which, at the time of the act of intercourse, the complainant clearly expressed that she did not consent to engage in such act as a reasonable person in the defendant's situation would have understood the complainant's word and acts as an expression of lack of consent to such act under all of the circumstances. What does that mean? If she's saying, no, this isn't right, that's probably a pretty good indication that there is a lack of consent. If, however, she says, well, I really shouldn't be doing this, I'm going to regret this in the morning, that's probably not lack of consent, but that's ultimately the job of the jurors. The jurors in this case have a very difficult job because, as we've talked about, they may not like Harvey Weinstein. They may think he is the biggest pig around. But intent can be shown, obviously, from the witnesses' statements about that particular evening, but it can be negated by the subsequent statements that they made. And each and every one of these witnesses had emails or some sort of communications afterwards with Mr. Weinstein that clearly show that they wanted to be in contact with him. And that is going to be the biggest issue, in my little humble opinion, as to whether the jury says guilty or not guilty. The jury's still out. We'll see. It was a 3-week trial, and the jury's only been out 3 days. I've said this before. I will say it again. Jurors take their jobs very seriously because they know that the consequences are great. A man's liberty, even if they don't like him, is at stake, and they want to make sure that they are absolutely convinced, beyond a reasonable doubt, to each and every element of the charges that have been brought. If the government has failed to prove just one of those elements, then the jury should find him not guilty of that count, because that is their solemn oath and obligation that they have taken. If the government fails to prove their case, they have to say not guilty. If the government has proven their case beyond a reasonable doubt, they should say guilty. We'll see how the jury decides, and we'll wait to see if the jury can decide. It may be a hung jury, and then we have to do it all over again, if the DA thinks they can do it better the next time around. Next on the docket, it can be a crime to make somebody watch the documentary Roots. Well, maybe not to watch the documentary Roots, but maybe to threaten them if they move and get up to not watch the 9 hours of Roots. That's right. An Iowa man is accused of forcing a woman to watch the influential miniseries Roots and threatened her with death when she tried to move. Robert Lee Noy, 52, is accused of going a little overboard. He made a woman watch the series, then threatened to dismember her after she attempted to move, according to police officials. He stated specifically, "If you move, I will put your body parts throughout I-30 on the route to Chicago." It's unclear exactly why Mr. Noy wanted this woman to watch the show Roots, but we can glean a little bit from a police statement, which shows that Mr. Noy wanted this woman to watch the Civil War era documentary / miniseries so that, quote, she could better understand her racism, end quote. Needless to say, the woman got away and was not dismembered and scattered over I-380. It is unclear whether, in fact, she has watched the whole 9 hours as well. Next on the docket, our dumb criminal contestant of the day. And this story comes from Ohio as well. Now, 36-year-old Solani Ketterpaul is accused of calling the police. Well, she is accused of calling the police several times. And why, you ask, would she be accused of a felony for calling the police several times? Well, because she phoned them stating that she was upset that her parents had cut her off in relation to her cell phone. That's right. Her parents had canceled her cell phone. She was arrested for disrupting public services after dialing the police twice with the same complaint. She was released on a $2,500 bond. Now, Miss Ketterpaul's father is a gastroenterologist and her mother is a pediatric dentist. So I'm assuming that they probably had the resources to continue paying on the phone. But Miss Solani Ketterpaul is 36 and a licensed real estate agent. We could probably guess why the parents finally cut off Miss Ketterpaul's phone. Is it that difficult? No, it shouldn't be. Because she's 36. That's why. If you're 36 years old and you can't afford your own cell phone these days, maybe you do belong in custody because you cannot take care of yourself. Anyway, Miss Ketterpaul, you are our dumb criminal contestant of the day. That's all we have for you on Crime Talk today. Thanks for watching. We'll see you next time.